Very good afternoon, everybody. I am delighted to open the fourth year of Tehran Regional Arbitration Centre, Vis Pre-moot, and welcome you to this very event. I feel a bit emotional because it just reminds me of around 12 years ago when I was a participant in Vis competition in Vienna, and I witnessed that how such a competition can involve the students in a semi-real practice of arbitration and help them to improve their skills. From that time in 2009, I've always had the hope to promote this event and this way of learning arbitration among Iranian students. In 2014, when I started my role in TRAC, I and my colleagues developed three separate ideas. First, organizing the first Iranian commercial moot court jointly with Arbitration Centre of Iran Chamber with the aim of fostering the study of international and domestic arbitration among Iranian students. The Iran Moot Court started in 2016, and now, at the moment, we are in the middle of the 6th year. In these years, tens of students and arbitrators have been involved in this moot, which had a great impact on promoting the Iran arbitration regime. Second idea was to envisage a dissertation cash prize for the Iranian students who choose their LLM thesis in the field of arbitration. Since 3 years ago that we started this competition, we increasingly receive dissertations in the field of arbitration, and I believe this program had a leading role in attracting the law students to research in the field of arbitration. The third idea is what we are now here for. Indeed, the third idea was initially just to support and sponsoring the Iranian teams in the Vis arbitration moots. I clearly remember when the first Iranian team in Vis, that was from Allame Tabatabai University, in 2015 came to TRAC, and the team members were all surprised that an arbitration institution is to support them in their journey to Vis competition. At that time, there was very limited awareness about such competitions among Iranian universities. This support of Iranian teams continued until 2018 when TRAC launched its own pre-moot competition. We started with only 2 or 3 teams, all domestic Iranian teams. That was also a great competition, but we needed diversity and more nationalities to make it really an international competition and different from our domestic moot court. Now, in the 4th year of TRAC Vis Pre-moot, frankly, I cannot hide my excitement that we are hosting 35 teams from 16 countries. Teams from Iran, China, India, Japan, Turkey, Germany, the Netherlands, Czech Republic, Georgia, Italy, United Kingdom, United States, Indonesia, Guatemala, Greece, and Uzbekistan. Also, great arbitration practitioners and scholars from around the globe are participating now in TRAC Pre-moot as arbitrators. Seems that my hope in 12 years ago is now coming true. And please note that this great participation is all in the situation that unfair international restrictions and difficulties are imposed on Iran, which is making literally everything, every little activity in global level, very difficult. Okay, please allow me to say some words about this year's competition. In the next 2 days, we will have almost 50 hearing sessions. Tomorrow is the general round in which all teams will battle in different positions of claimant and respondent. The sessions have been arranged in a way that the teams will rotate and each team will see its counterpart and the panel only once, so that the teams will have the opportunity to interact and be challenged by different competitors and arbitrators. The arbitrators will give their comments to teams, and they will score the teams based on certain criteria. At the end of tomorrow, 8 teams will make it to the next round. In the second day, Wednesday, we will have 4 quarters, 2 semifinals, and 1 final round. That's it. I wish good luck for all teams. I should also say that very motivated administrative and executive teams are now running the competition from here in TRAC. They will monitor all hearings, and therefore I invite the participants to feel free to contact the executive team if they might have any question of any kind during the next 2 days. I know they won't sleep in the next 2 days, so contact them at any time you wish. I should also thank here my colleagues Kamyar Ouladi and Masoud Mahboub, who managed this whole event, and Zahra Hossein-Poor, who was in the executive committee from the beginning. I should also thank all students who volunteered to help us in this busy week. They are all now there in the TRAC hearing room. I wish I could show them to you, but I assure that they are wearing their masks, doing their tasks. The windows are also open for fresh air. And today, in the opening, we have great distinguished speakers. Right after me, we will have Dr. Hamid GHARAVI, the president of TRAC International Board. Dr. GHARAVI is an Iranian-French lawyer with very great experience of more than 200 international arbitrations, either as counsel or arbitrator. Dr. GHARAVI will share some insights regarding virtual hearings and the practical matters that might arise in this regard. This talk would be very helpful for the mooters who will have their first experience of virtual hearing this year. After Dr. GHARAVI, I will invite Dr. Patricia Shaughnessy, also a member of TRAC International Board. Dr. Shaughnessy is a professor of dispute resolution and commercial law at the Department of Law, Stockholm University. She created and for 15 years directed the Master of International Commercial Arbitration Law program at Stockholm University, an excellent program. And for all these years, she was actively participating and coaching and advising teams in Vis competition. Dr. Shaughnessy will talk about the skills that the mooters would learn in the competition and the way that such skills are used later in real practice. The last but not the least is Professor Ronald Brand, the driving force behind the creation of the University of Pittsburgh's Center for International Legal Education and its Master of Laws program for foreign law graduates. Professor Brand has lectured on international trade and business law at different universities in the US and abroad. He is the co-author of the book, The CISG and the Business Lawyer, and considering his strong background and expertise, he is invited to kindly discuss the application of provisions of CISG in international trade law. Okay, I would stop here and invite Dr. GHARAVI, and I sit here to learn from our distinguished speakers. Thank you very much for your attention. Dr. GHARAVI, you have the floor.
Very good. The advantages of virtual hearings. The advantage is that it works well, it is very effective. To a point, I must say that during the last weeks, I had 2 occasions where both parties scheduled and agreed virtual hearings for the beginning of 2023 and one at end of 2022, and insisted that they would want virtual hearings even if the COVID crisis would allow in-person hearings. that is very telling, I think, of the success of virtual hearings. It works without disruption. The technical disruptions are very minimal. Um, the integrity of the proceedings is safeguarded in terms of witness cross-examination by virtue of oaths, physical representation by an opposing party's representative together next to the opposing witness or expert, or by 360-degree cameras. Um, I must add that in practice as an arbitrator or even as counsel, I think that counsels avoid sandbox type arguments, fights, and focus on the essential points during virtual hearings, as opposed to when they are in person hearings. Also, I think it is very effective in terms of conveying one's case if and subject to presenting slides that contain references, I must say, to the evidence that you are on which you are relying. In practice, in-person hearings, whenever you want to convey your case as counsel, I usually take binders, highlight the relevant parts, and walk the tribunal through the relevant portions of each of the material exhibits. In virtual hearings, you cannot do that effectively, so it is very important to prepare slides to reference to the exhibits and the passages in the exhibits so that the tribunal follows, and in this way also they have a copy of the slides once the hearing is over. A cross-examination is effective, but only if you go directly to the material points and you avoid bringing indirectly the witness too much into the relevant point, which you often tend to do when you are in person hearings. But in the virtual hearings, you have to try to go, I think, directly to the point. That is more sufficient. And make sure you coordinate with the service provider or your team to so that the relevant exhibits are promptly displayed on the other screen for the tribunal members to follow. So I would say overall, it is extremely effective. I don't think that there is one case as an arbitrator when I came out and I said, oh my God, if we had done it in person, it would have been more effective. Or let us complement that by way of a closing oral submission eventually in person. However, there are not only advantages, there are certain disadvantages. And I think the disadvantages are mainly for counsel because, and this point is underestimated, I would say, by tribunal members who have no experience or no recent experience as counsel. As arbitrators, we have the luxury of preparing in our homes, in switching on the computers, and even taking breaks, spending time with our family, a cook who prepares a nice dish. But as counsel, it is hell. It is hell because it is very time consuming to prepare virtual hearings, particularly if you do not have staff. And in certain jurisdictions, I must say, especially in France, access to staff is limited because there are restrictions on social law restrictions that do not allow you to push too much the employees to come at work during sanitary crisis. Also, so associates basically end up doing paralegal work in addition to lawyering. Also, it may sound trivial, but it is not. What do families do that have children, who have children? It's very difficult during these days to find reliable babysitters that are not floaters, that work with limited number of families, where the risk of COVID, them transmitting or catching COVID would be low. So effectively, at night, sometimes you do your work while babysitting, and it is very difficult for associates who are married and have children to juggle counsel, hearing preparation work, as well as their family work. Also, I must say it is very challenging when you're arguing before tribunal members who are not gathered, because sometimes you have virtual hearings, but at least the tribunal is gathered. But most of the time, that is not the case. Worst, most of the time, the tribunal members are at the different time zones, even counsel. So you have odd hearing hours, sometimes at 4 a.m. Right now, every week, I wake up very early to hold hearings because a member of the tribunal is in Australia, others in the US, split in everywhere in the world. And I think it is very challenging because the tribunal members do not have time to interact, to meet, which you always do when you have a in-person hearing. You meet the eve or the morning at least of your hearing. You meet during at dinners during the hearing. You meet during breaks. You can prepare and focus on the material points, even deliberate on an ongoing basis some of the issues. Group questions, focus on the material questions, all of which you cannot do. And I would say the downside I've seen of virtual hearings is that there are limited number of arbitrators that ask questions. Now, is it because the situation does not allow? Is it because they are not sufficiently prepared? Is it because they do not coordinate and don't feel at ease to ask questions without sufficient interactions with other co-arbitrators? But in practice, I have seen this occur. These were the advantages, I would say, and the disadvantages in practice of virtual hearings. But on balance, again, it works quite well. Now, few words on legality. In practice, issues of legality do not often arise, but they do arise. They don't often arise because there is most of the time consent either to have a virtual hearing or consent to postpone and have a in-person hearing. Also, I must say that sometimes the situation is clear because the law expressly provides for virtual hearings, such as the case, for example, of the UAE law, the 2018 UAE law, federal law, that expressly authorizes the conduct of virtual hearings. But when the issue arises, I would say it's often the respondent that has the short end of the stick. When the claimant opposes a virtual hearing, tribunal members accept to postpone and so as to allow an opportunity to have eventually a in-person hearing. But when it is the respondent, there is sort of a presumption that the respondent is going to delay or is making a frivolous objection, which is, I must say, often unfair. I represented Egypt and Romania in recent exit cases, and I can tell you that I was making a valid objection to postpone the decision of holding a virtual hearing so as to allow a in-person hearing, simply because the time frame between the last submission and the hearing was too short. There was no opportunity to meaningfully prepare witnesses that were abroad virtually. It was not possible. My client, which was represented governments, could not travel for purposes of giving instructions during the hearing. Some of the witnesses were officials of a government and they were never testified, and they did not want to do so virtually for the first time, and also without the in-person preparation first with their counsel. Plus, there were, as I mentioned, some serious impediments in terms of staff in France in terms of preparation. So I think that is unfortunate, and I did record the objections. Now, um, the problem with objections in practice is that not many parties link it to a impact. For an objection to be valid, it has to go beyond the issues of convenience. It has to materially impact, at least on due process or a fundamental rule of procedure. Otherwise, it is unlikely to work. Case law is scarce because the virtual hearings have been held only for the last year or so. But I think in the upcoming 6 or year or so, there will be more and more cases. So far, we have had mainly decisions ruling in terms of challenges of the tribunal members who have taken the decision to hold a virtual hearing. We have had decisions from national courts, such as the Vienna court, I think, of the date is July 23rd, 2020, in a administered case under the auspices of VIAC that dismissed the challenge. And there are two exit cases, Vantefal versus Germany, July 2020, and the December 2020 decision in Landsberg versus Spain that similarly dismissed the challenges to the tribunal members that have taken the decision. Yet, one thing is to dismiss applications for challenges of arbitrators. Another is when it gets to annulment or enforcement of awards. And that will be telling when the cases arise to annulment and enforcement to hear what the courts have to say. And I must confess that tribunal members must be vigilant to not misuse or abuse the discretionary power that they have been given in practice to hold virtual hearings when there is an effective challenge that is linked to due process considerations. And I must say that this is particularly the case in ICSID because of Article 62 of the ICSID Convention that provides that the default seat should be Washington, D.C. If the drafters of the ICSID Convention held that the tribunal members cannot meet to hold the hearing outside the seat of the arbitration unless there is a consent of the parties, I think there is a good argument to say that absent consent, they can also not have a virtual hearing, particularly if, as I mentioned, there are due process implications in practice. These are, within the time that I was afforded, what I wanted to share with you. I hope we will have time for certain questions, and I thank you for your attention.
Thank you very much, dear Hamid. Well, one question, is there any concern
Thank you very much, dear Hamid. Well, one question, is there any concern about the cross-examination and the way that the witness might appear in the virtual hearings? I'm asking because the cross-examination is one of the most important part of the hearings, and some of the counsel are used to put some pressures on the witness and then ask for the questions that they are looking for. So, is there a risk that when the pressure is becoming over and over on the witness, by accident the connection disconnects, or the witness is being trained from back of the camera?
I haven't witnessed it. I mean, I don't think there is room for cheating because in the most important cases, there are 360-degree cameras. Sometimes the opposing counsel sends someone to be next to the witness. In terms of cheating, I think the risk is quite non-existent, if not close to zero. In terms of effectiveness, I think it is very effective as long as you avoid, as I mentioned, going through the circles before getting to the material point. Nobody has the patience of this on a virtual hearing. Also, the platform does not allow such an ambiance to be created for that technique to be effective. But otherwise, if you go directly to the point And if you have a team member that have prepared the cross-examination with you by prompt references and display of the exhibits on the second screen with the relevant passages highlighted, I found that as counsel and arbitrator to be extremely effective on balance, not to there is nothing worthy that is missing when compared to the in-person hearing.
Thank you. Thank you very much. Very helpful and very interesting points. So if I may, I will now invite dear Patricia to take the floor, and still we are listening and learning. Dear Patricia, you have the floor.
Thank you very much. And let me start by asking, can you hear me well? Is my audio working efficiently?
It's working. I can close my eyes and imagine that I am in the classroom in the Stockholm University and Patricia is talking. That's the way.
Great. Thank you so much. And let me thank not only Oveis Rezvanian and all of TRAC for the really impressive work that they've done. This pre-moot, having gotten to this global point in just a few short years, is a result of a lot of hard work and vision and leadership. I'm really impressed. I'm sure the students are going to have a robust learning experience. And that's, as we're now nearing the end of the journey, and I'm happy that Oveis used the term journey. I think it's more than a metaphor. This has been a journey, an arduous one for the students, but hopefully an exciting one, and one that you're going to be reaping the benefits of throughout your entire professional and indeed even your personal lives to come. This has been a transformative learning journey for you. Imagine for, I think, probably all of the Vis Mooties, that 5 years ago you were clearly ambitious law students who were eager to join into the international arbitration community. You were learning law and you were gaining understanding and knowledge about how law worked. Some of you might have even been learning law in environments which had moved over to the idea of teaching critical thinking and teaching students to think like lawyers. But after undergoing the Vis experience, you are going to be transformed, as one of my former Vis students expressed to me quite aptly, I thought. I came to Stockholm having already learned to think like a lawyer. But after doing the Vis, I had learned to think like a lawyer with a client. And that is a big difference. You have, during the past 5 months, been learning and transforming to think like a lawyer with a client. And what I mean by that is you have been learning and continuing to learn in the few weeks you have left, and as you embark on your career, to be using law to achieve the commercial objectives of a client. Now, if you're working in various business situations in commercial law, that client may be a company. But even if you're working within the company as an in-house counsel, even if you are working in other contexts and organizations, there is an end user who is seeking your advice that you need to be serving. We are in a service industry. And for most law students, you've had little opportunity prior to the Vis to really engage in thinking about the commercial application of what you are learning. And this transformative experience, I think, for many of you, has been going from learning what should be the right answer, the answer which will give you good points on the exam, the answer which will give you a good mark on your memorandum or your thesis, and moving instead to see the importance of formulating questions, of asking questions, of characterizing issues, because the way in which the question is formulated or the issue is characterized will create an analytical pathway which will lead to different answers, which you can then analyze, evaluate, test, select, and advocate. And this is a bit different from what you were learning before you embarked on your Vis journey. And I think you will find that the skills that you are learning in this transformative learning experience are going to be really key, important professional skills that you will be using and developing further in your legal careers. One of the important professional skills is careful reading, that you need to be an active reader, carefully reading. I would like each of you to think how many times you have already read the Vis Moot problem, and how when each reading you start to find new nuances, new little bits of information that you can put together to help create a convincing argument. And I would encourage all of you between now and the Vis that you should read that problem at least a couple times a week. You should read it during the general rounds of the Vis, because you will continue to see new things in your careful reading, because you now have the lenses of having worked on the problem and going through the pre-moots, which have given you new insights to the information you're taking in. And I think you will learn that working as a practicing lawyer, you need to be fact-based and outcome-focused. You must start with the facts and looking at the facts and how you can put those facts together into the vehicle of legal doctrines to arrive at the destination of the outcome which would best suit your client. And you must always maintain your credibility. Never sacrifice your credibility. You must be correct in your characterization of the facts. You must be correct in your representations of the law. And you bring these together into what will be a convincing argument. And sometimes in the beginning of the Vis, you had to go through the clarifications process, asking, is there more information that we need? Are there things which are unclear? Trust me, I practiced law for 10 years before I became an academic. And I quickly learned when I practiced law that the first meeting with the client is just the beginning. They never present all the information that you need. You need to go back and ask for more information, clarifications, more precise information, and you need to find out what information is there that they didn't give you, but the other side may have. And so during that clarification process, you were learning about having to really carefully go through the facts. Another important skill that I cannot overemphasize is honing your listening skills. You need, during the time that you were preparing for your everything you've done and doing your memorandums and preparing for the oral arguments, you have had to listen carefully to your teammates, to your colleagues, to your coaches, to really listen and see, am I really getting it? And you need to continue honing those listening skills as you head into the Vis, because the most important thing I think that you can do when you're doing the pre-moot and when you're doing the Vis and in real life and real hearings is carefully listening to what the other side is saying, and especially to the comments and questions of the arbitrators. You must listen. Don't think, I got it, and already start constructing your answer. Listen carefully, and then be sure that you directly address the concern that's being raised. And after directly addressing it, if need be, elaborate, explain, make exceptions. But your listening skills are just as important as your reading skills in a lawyer. Listen before you talk and read before you write. And this leads to the communication skills. How can you effectively communicate? none of us, not even Nobel Prize winning literature writers, not even the best speech makers or TED talkers, just do it automatically. Communication skills rely upon having a clear message, clearly thinking through what are the key points, the key takeaways, what you want the listener to remember when you finish, putting the important information up front, providing whatever support that you need, and concluding so that you wrap it all up. Another skill, which is not unique to law, but is one that a lawyer must have, and that is the ability to shoulder responsibility. It's a huge responsibility to be a lawyer, to serve a client, to be relied upon, to be paid for, to be expected to provide professional service. And you need to be able to shoulder that responsibility. And doing this Vis, all of you have had to shoulder responsibility. You've had to prioritize tasks, learn to multitask, learn to meet deadlines, learn that good writing is rewriting, and you have to do the 7th and the 8th. And you must deliver this in time for the brief, for the arguments to get properly developed. It cannot wait to the last minute and you pull a rabbit out of the hat. It will not be a rabbit you pull out of the hat, not a live one anyway. And during this Vis, you have learned to shoulder responsibilities, prioritize tasks, find milestones that need to be delivered upon, and how you can actually gain momentum and gain encouragement by meeting those milestones when faced with a large task. And another important thing that is going to be key in almost any job you'll have, there are very few jobs you will have as a lawyer or not as a lawyer that do not involve working with other people, working with your colleagues, working with your clients, working with the arbitrators. It's a collegial process trying to get the arbitration completed. You must learn to have the kinds of skills to work on a team. And I think that all of you have probably had challenging moments during the Vis. You don't always agree, but you need to, as Ruth Bader Ginsburg loves her famous quote, you can disagree without being disagreeable. And you can work towards a common goal without having the same path that way. The teamwork that you're learning, I think, is really important. And I hope that you're all being able to take out of the Vis experience, this is a positive lesson learned, despite the sometimes challenging situations that occur. And finally, one of the really important things for you is that you have learned, as I already said, so I will finish with that, to not just think about law as some pristine, intrinsically valuable thing to study, but to see law as a way of solving problems, different kinds of problems, societal problems, and importantly, commercial problems. During this exercise, you've been engaging in a number of complex issues that went about in the context of remote hearing challenges. As you know, in dealing with intellectual property licensing issues, in dealing with multi-party arbitrations, and what kind of realistically commercial and practical solutions the law can provide. And as I like to say, it's the hand in the glove. You know, a glove doesn't have much use without a hand. And we need to be able to put the glove of the law onto the hand of the client. And to think of things in a commercial, that in the couple of weeks that you have left before you end this journey, that you will find that the end of the journey was not the point. It was the journey. Because what you have gained, how you have transformed as an individual, as a lawyer is going to be reaping benefits and going to continue to transform your life in the years to come. And lastly, you have joined a community that welcomes you, that congratulates you, that is impressed with your work. You're in the community of the Vis, and you are in the community of international arbitration. And we all need all of you, and we welcome you and thank you for your willingness to work hard. And I hope that you will continue to contribute to our community throughout your profession.
Thank you. Thank you very much, Patricia. Very helpful and very interesting. Well, I've got a question. You know, a part of the Vis Moot is the attraction of the meeting new people, making parties, gathering together, and everything that we know as students. The people come here, the students come here to know each other more and see people. Now we are having virtual hearings. For real clients, for real cases, it's good because virtual hearings means less costs and cheaper proceedings. But for students, maybe it results in less attractions. So did you feel something like that or no?
Oh, I don't think there's anyone on the arbitration planet that is not very sorry that for the second year in a row that we will not be meeting in Hong Kong and Vienna, and being able to have that really unique experience of spending about a week together in the moot activities and all the related social activities. On the one hand, this remote situation has provided lots of opportunities for students to attend webinars and pre-moots and to even the playing field to a certain extent, because they wouldn't have had the budgets and the possibility to get away from their studies to go to all these events. So it has opened up for many. But I would really urge all of our mooties to plan to come to Vienna next year, to come if you have enough experience to act as an arbitrator, if not just to come as a Vis Moody alumni and participate in the different activities that will be live there and to enjoy the live environment. Vienna and Hong Kong are wonderful places. And if you come, I hope I can meet you because I really miss meeting students. As Oveis knows, I always say I serve on the energy and vicariously live through all the wonderful, ambitious students I encounter. So I would love to meet all of you.
Thank you again. Yeah, please go on, Hamid. Please.
I wanted to thank Patricia for conveying the messages. I know it was not exhaustive, and I wanted to just emphasize when it is said that we should listen to opposing counsel and tribunal members, to tell to all the participants that you have to also make sure that you listen to your own witness and use the redirect on examination to clean the record if something harmful and wrong has been said by the witness. Often the redirect is ignored in practice, and it is a shame. The second thing is also listen to your own colleague, because sometimes the work is spread and someone scores a point on the point that it has responsibility for, but hurts the other side. And so listen to your colleague and make sure you have an overall picture of all the points of the case and not just the part for which you are responsible.
Thank you. Thank you very much, Hamid. Excellent. So now we are all going to learn more from Professor Rand, and I thank you in advance for accepting and attending this session. And you have the floor, Professor.
Thank you. I want to begin by thanking the Tehran Regional Arbitration Centre, everyone there, for putting this program together and for having this pre-moot. It does demonstrate what can be done with remote connections that we couldn't always do in on-site programming. And I really commend you for the way you put that together. I really appreciate the opportunity to speak and be a part of this, because I remember that first Iranian Vis Moot team, Dr. Rezvanian, Masoud Mahboub, and when they came to the first, to the Middle East Pre-moot in Amman, Jordan, and we worked together there to help understand the Vis problem. And I really am amazed at all that you have done from that time forward. You've done a wonderful job of bringing the Vis Moot to Tehran. I do believe this is the single best legal education platform that exists, the Vis Moot. There really isn't anything that's been designed better for purposes of legal education, and to have you using it in this way, I think is wonderful. Now, I've been asked to speak about application of provisions of the CISG as customary rules. I do have some PowerPoint slides. May I share those, Dr. Rezvanian? Am I coming through okay here? The sound? In order to share those on this platform, I just want to make sure that I have the right.
Yeah, everything is perfect. Yeah.
Okay. Can you see the PowerPoint?
Not yet.
Okay.
There is an item there, desktop sharing. If you might share your desktop, you can see the PowerPoint.
Okay. Okay.
Computer symbol.
Now, does that come through?
Yeah, excellent.
Can you see that? Okay. The problem is I cannot see you, but that we'll work with that. So I want to deal with this issue I've been given, and I'm going to do the following. I will begin with application of the CISG under its own terms, then look at the concept of customary rules, asking the question again, can provisions of the CISG be applied as customary rules? And if so, by whom and what is required for that to happen? I think it's useful in doing this to look at the history of the use of custom as law, and that takes us to the concept we know as Lex Mercutoria. I think it's also useful to remind ourselves of the use of customary rules in public international law and how that has developed, but then to bring us back to customary rules in private international law. And in that, I will distinguish between private international law and international private law, look at the application of customary rules in national courts and in arbitration, and come back to the question, the application of provisions of the CISG as customary rules. Now, if we look at the application of the CISG, we begin with its own terms. And Article 1 tells us the rule for that. It tells us that when we have a contract for the sale of goods that is international, in other words, between parties in different states, the CISG applies in two circumstances. One, when the states are both contracting states, or even when the state law lead to the application of the law of a contracting state. Now, that still leaves us with the question, can provisions of the CISG ever be applied as customary rules? Well, not under Article 1.1a, because it would not be necessary. If we have a contract for the sale of goods between two parties who have their places of business in different states, and those states are both contracting states, then the CISG applies as law by its own terms. If we look at Article 1.1b, we ask the question, can the rules of private international law ever lead to the application of something that is not law for the parties and the states involved? And then we have to ask, can the provisions of the CISG be applied other than through Article 1.1? Because Article 1, Paragraph 1 is the gateway to the CISG as the rule of application. And the question then becomes, if the CISG can be applied in any other manner, by whom and what is required for it to happen? This takes us to the concept of Lex Mercutoria. Now, Professor Harold Berman, in his 1988 article, looked at Lex Mercutoria, the law merchant, and determined that it had five principal characteristics. But importantly, it governed a special class of people, merchants, in special places, because it was developed in the fairs, the markets, the seaports. It was not the same as the law. The few things are important. It was transnational, it was speedy and informal, and it stressed equity. But two of those are key to our discussion here. Its principal source was mercantile custom. In other words, it was the custom of the merchants that determined what the rule was. Second, it was administered by the merchants themselves, not by professional judges. Now, that we have had as the source of law and adjudicative mechanisms, primarily courts. In civil law states, we see that in the rise of codes and the way in which codes become the source of law. In common law states, we see it in the evolution of the way judges determine what the law is. In England, for some time, it was common in a case involving merchants to have a jury of merchants who would tell the judge what the custom was in the particular trade, and the judge would use that as the source of the rule. But instead, said that's not the way it's going to be. We must consider it as a point of law, and judges tell us what the law is. Now, this raises the question, can the CISG be the new Lex Mercutoria? Have we moved from custom and merchants determining what the law is and applying the law to courts and states giving us the law and administering the law, back to the role of merchants in the process? How, if at all, can what is otherwise designed to be law be applied as custom? Or can custom be applied as law? I think it's useful to look at public international law here, because in public international law, we all know that custom is important. And on 38, we can look to treaties, international conventions. Under 1C, we can look to general principles of law. But that third source, and in many cases the most important source, is customary international law. But customary international law is proved when we can show a general practice of states that's accepted as law. In other words, states engage in that practice because they consider themselves bound to engage in that practice. This raises the question of whether similar concepts can apply in private transactions. Now, we do know that treaties can be used to help state what the custom is. The Vienna Convention on the Law of Treaties often is used in that way. States like the United States that are not party to the Vienna Convention often acknowledge that the provisions of the Vienna Convention on the Law of Treaties are statements of customary international law. This then brings us to a question of whether the same can't be true in private matters. Does that other Vienna Convention, the UN Sales Convention, state rules that would otherwise be considered custom and could thus be applied as law. So in public international law, custom can be applied as law. The CISG, after all, is a treaty, so it is international law. But public international law requires the involvement of the state, and the CISG most often applies to transactions between two wholly private parties. So the question is, do the same rules of custom apply? When we move to private international law, and here we have to distinguish between private international law and international private law. Private international law is that set of rules that tells us how we determine or decide disputes between parties from different states when a transaction crosses borders. And primarily in private international law, we are looking at three things. We are looking at rules of jurisdiction, rules of applicable law, and rules of recognition and enforcement of judgments. And for our purpose now, we're looking at that second one, the rules of applicable law. Now, the concept of international private law, the CISG is in fact international private law. It is international law that becomes the law of the states, the contracting states, but it is designed to deal with private matters. Now, if we go back to Article 1, in particular Article 1.1b, we have a rule of private international law. It says the CISG can apply if the rules of private international law, the conflicts rules, the rules of applicable law, lead to its application, but only if it leads to its application as the law of a contracting state. It doesn't say its application as custom. It is application if the rules of private international law lead to the law of a contracting state, and the law of that contracting state is the CISG for international contracts. But there has become an important distinction between law and the term rules of law. Now, that is often a difficult distinction to comprehend, because if law is a set of rules prepared by a sovereign, how can rules of law, using the term law, not be from that same source, a sovereign? But this distinction is between law created by a sovereign and rules of law, rules that are created not by sovereigns but by others. A good example of that is the Incoterms of the International Chamber of Commerce, or other different similar instruments created by merchant bodies. Now, when we think of the application of law to contractual relationships, one of the good examples of rules of applicable law is the Rome I regulation of the European Union. Article 3 of that regulation tells us the basic rule: a contract shall be governed by the law chosen by the parties. And Article 4 has the default rule: if the parties have not chosen a law, then in a contract for the sale of goods, that contract shall be governed by the law of the country where the seller has his habitual residence. A very specific and predictable rule. Now, when this regulation, at least when it was revised from the Rome Convention to the Rome I regulation, there was discussion of allowing parties to choose not just law, but rules of law, or Lex Mercutoria. And there was discussion of having that be part of the default, but that was rejected by the European Commission. Some argued that was undemocratic, and that the law has to come only from the sovereign. Now, in arbitration, it's important to see that matters have evolved a bit further than the Rome I regulation. If we look at the UNCITRAL model law, the rules of applicable law are similar to use in accordance with such rules of law as are chosen by the parties. But see the difference here. The parties can choose not only law, but rules of law. They can choose other than sovereign sets of rules. But The default rule remains. Failing any designation by the parties, the tribunal shall apply the law determined by the conflict of laws rules which it considers appropriate. So they must apply rules of applicable law, but can apply them only to get to sovereign bodies of law, not to rules of law. Now, the Untitled Arbitration rules follow the same pattern. The parties may choose rules of law, but if they don't, the tribunal, though, can apply the law which it determines to be appropriate. But see that the path to that law is much more direct here. It does not have to go through rules of private international law, rules of applicable law. They can simply choose the law they determine to be appropriate. Now, the SCAI rules go a step further and say that the parties can choose rules of law, but even when they don't, the tribunal may apply not just law, but rules of law, which could be custom. But they must apply the rules of law with which the dispute has the closest connection. The ICC arbitration rules in their most recent draft, 2021, say that the parties can choose rules of law, and in the absence of such agreement, the arbitral tribunal shall apply the rules of law which it determines to be appropriate. It's not, there's no closest connection requirement. It's simply the tribunal can apply the rules of law which it determines to be appropriate. Those can be law created by sovereigns, they can be otherwise. This direct approach to rules of law by an arbitral tribunal is adopted and endorsed in national laws, France, Ontario, India, Kenya, the Netherlands, and in other sets of arbitration rules, notably LCIA, the SCC, and the WIPO rules. So, that's a quick run-through application of the CISG with attention to the question of whether the CISG can be applied as customary rules. If we go directly to the question, can provisions of the CISG be applied as customary rules? The answer is yes, in arbitration, in limited circumstances, but with greater frequency as the result of changes in arbitration laws and rules. So even though it's limited application of custom in arbitration, you can get there in arbitration in ways that you probably can't in litigation, and the CISG can be applied as customary rules. So, with that, I hope that I can no longer, I need to, there, okay. Are you back to seeing me instead of my screen now? Okay. I hope that's useful. For the students here, it may not directly apply to the problem in this year's Vis Moot, but I think when you're arguing that problem in the Vis Moot, what you need to understand is the broader context, just as if you need to understand the entire CISG to argue one article of the CISG, you need to understand the entire context to argue when certain rules are applicable to a given transaction. I wish you all the best, and once again, I want to express my thanks to TRAC and everyone involved for putting this program together.
Thank you very much. Thank you very much, Professor Brand. And the last question that you just posed, if the CISG can be applied as the customary rule in arbitration, and what is the answer for court, for litigation? No?
Well, the answer for most courts is that the rules of private international law can only lead you to law. Just as in the European Union, when they revised the Rome I regulation, they debated that question. And there were many who wanted to have the language specifically allow them to lead to rules of law. Now, it is the case that parties can choose rules of law. Parties, even parties in states that are not party to the CISG, can choose the CISG as the applicable law. And so it can be chosen that way. And that raises the question, when they do so, are they choosing law or are they choosing rules of law? Now, either way, you need to we all know that you need to choose a gap filler. This is important in the transaction planning process. Now, obviously, if you plan your transaction properly, and this is not for the dispute resolution lawyers, but for the contract drafters, okay, you should always have a very clear choice of law clause, and you shouldn't leave this question open for the tribunal if you draft your contract properly, because when you leave the question open, you remove predictability from the contract process, and that you don't want to do.
Thank you. Thank you very much again. I see that the question and answer is already there, and I don't know when Hamid GHARAVI got the time to write all these there, but well, yes. Hamid, do you want to add something to what you noted there?
No, nothing. I think I answered. There may have been a misunderstanding on the use of the need for babysitters. I was asked the question, but if you have a virtual hearing, you have to travel. You need babysitters. Yeah, I said, of course. You even need more babysitters, given if you're traveling. But the question was virtual hearing as opposed to postponing until the situation gets better and the COVID crisis is over. The second question was outsourcing. Wouldn't it be possible to outsource? And you would see, everyone, that when you're in your office close to the hearing, when I say you need staff, it is not the staff outsourcing that is useful. You need until the last minute to print slides, exhibits, highlight the relevant portions, demonstrative exhibits. These are working drafts that change until the last minute. Someone elsewhere, sitting elsewhere, who has no clue of the case, is of no use at all.
Yeah, I understand. Thank you. And I've got another question from you, Hamid, before I ask my question from Patricia. If one of the parties is requesting for a virtual hearing and the other party, perhaps the respondent, is not accepting, what should the arbitrator do? I mean, is there a concrete answer to that? And let me ask the next question also, the follow-up question. If the arbitrator forces the party to virtual hearing, could it serve as a ground for setting aside of the award later because one of the parties alleged that it was the violation of the due process? I'm saying I needed an in-person real hearing so that to present my case and show the documents to the arbitrator in person. I mean, is it this way or no? The arbitration has the required discretion and should not be worried about that.
Well, that was a little bit the points that I briefly covered, but your question is more elaborate. Today in practice, when a respondent opposes and claimant insists on a virtual hearing, in practice, it's tough luck for the respondent, unfortunately. The tribunals uphold their decision to hold a virtual hearing. So far, when challenges have been made, it has been within the context of the challenge of the arbitrators for lack of partiality, for bias in decision making. It has not gone to the annulment or enforcement stages. But as mentioned, I have reserved the right of my client, Romania and Egypt, at exit because there was a effective impact on the hearing preparation during COVID crisis, when there is a distanciation, when there is not enough staff, and when my client cannot travel to give me instructions during the hearing, when the witnesses who are officials of the country in one of these cases cannot travel to Paris without burden. And in fact, one of them did did a COVID test before going on board. And when he came in Paris, he did another test and was positive. So in between, he contracted COVID. We had on the cases against Romania, 2 of my staff who contracted COVID. These are not acceptable conditions for preparing a hearing. So when it is linked to an effective impact, I think there is a case to be made if recorded and made in good faith. And history will tell us when many of these cases come to annulment or enforcement, what the courts would have to say.
Right. Okay, thank you. And Patricia, in the last, let's say, 15 years, you have seen many students in the Vis Moot. Many of them shined really in the competition. Could you just say that the students who shined in the Vis Moot later became successful or shining lawyers and counsels as well in real practice?
Can I be a politician and answer a different question than the one you asked? No, Veen, to answer your question, of course, many have. There's many great examples of Simon Greenberg, for example, was a great Mooney and went on to be Deputy Secretary General at ICC. You can think of many, many practicing lawyers who have had great careers because the same ambition and hard work and intelligence and all that lifted them in the Vis continues to lift them. And it's definitely a good thing to have on your resume. It shows that you have an interest in arbitration. It shows that you're willing to work hard, and it gives you something to discuss if you get an interview and such. But I thought you were going to ask me when you started the question. See, that's why you should always listen through. If I could say there's something that made a particular pleaders stand out during the Vis to get high scores, that's a different question. And I would say in answer to that question, which you didn't ask me, I think the thing that really makes a standout pleader is one who listens and answers the question that was asked, and does so that they show this agility to be able to move between the facts and the law, to be able to put forward the arguments, to directly answer the question, to view the interaction between the pleaders and the tribunal as being a respectful conversation where they're trying to achieve deciding these issues. And I think that it's the students who really agilely, seamlessly move between the discussions with the tribunal and back into their pleadings that are standout. And I think that type of agility is the result of a lot of preparation and hard work and knowing the case well. And that will make them do well as practicing lawyers as well.
Excellent. Thank you. Thank you very much. My last question goes to, please go on, Professor.
I'd like to add, if I could, a little bit to that. I think we've seen, our Center for International Legal Education has worked with teams in a lot of countries on the Vis Moot, and we've used the Vis Moot as a curriculum development tool in law schools, but we've seen wonderful progression from the Vis Moot to further study to careers. On this screen, we see you. You're an example of that. We have a number of the people that we've worked with that are now professors in law schools, that are now successful lawyers in international law firms. And I'll give you one example that demonstrates the kind of broader value of the Vis Moot. We've done work in a number of countries where we use the Vis Moot to identify really strong students, have them come to Pittsburgh for an LLM, and then they go back and we hope they make a difference. Well, one of those students, one of the first that we did that with in Kosovo, was a young woman named Vjosa Osmani. She's now the acting president of Kosovo, and she's using all of those skills she learned in the Vis Moot in that context. And so I think that again, I think there's no better platform for legal education, and I think that the set of skills that you learn in the Vis Moot can serve you well in the legal profession, in academics, and certainly in many other ways.
Yeah, thank you very much. Well, my last question goes to, again, Professor Brand, and I see that one or more questions are there. So if I may, I ask my question and leave it to Professor Brand to answer any of those questions as well. So my question is, when it happens to all of us that when we are studying, we learn something, and later in practice, we find out that, well, it's a little bit different in practice. I mean, what we learned and we read in the books might be different from what we actually see and should apply in practice. Believe it or not, WIS is an academic event. So there is no real money there. There is no real client and real claimant and respondent. And the students are coming from the university reading the books. Do you see any serious difference between the way that CISG is being applied in an academic event like WIS and the way that it might be applied in a real case out of the academy?
The answer is yes, maybe. I think that it is important that you understand, whether it's a CISG or any other law, what the path is to that law. And again, the best path always is clear language in the contract. And if you draft the contract well, you prevent these problems. If you leave the matter to default law determined by the tribunal, whether that be a court or an arbitral tribunal, you leave open the possibility for problems. But here's where the CISG, and in the United States, it's still a problem. It's when judges don't know the CISG well, and they default to domestic law, or there's a series of cases in the United States that basically says, well, the CISG has the same purpose as the Uniform Commercial Code, so we'll just look at the Uniform Commercial Code. And that is problematic. I like to think that if the counsel whose clients benefit from application of the CISG understand it well and argue it well, they can explain to the court, the tribunal, why it is that the CISG applies and how it applies. But it's still an area where the Vis Moot has changed this dramatically on a global basis. Nothing has made the CISG better known than the Vis Moot and better understood. And so it's that problem is less than it used to be, but unfortunately it still exists to some extent.
Excellent. And do you want to answer the question posed there by NCA and the previous one, I guess? Can
award be denied? Can award be denied enforcement because the CISG was applied due to one party claim stating that it should not have? Well, that's an interesting question because what can be the grounds for denial of recognition and enforcement under the New York Convention? One of the grounds that's not available is that the tribunal misapplied the law. The process of recognition and enforcement, the process of annulment is not the same as an appeal of a court judgment. And so it has to be something more than just misapplication of the law. That's one of the reasons the parties choose arbitration, is to get resolution that's not subject to appeal, but with arbitration comes the risk of a bad decision on the law that you can be stuck with. I mean, that's the nature of the choice when you choose arbitration. And so, but the New York Convention requires something more egregious, either in terms of denial of due process or resulting in award that's so egregious that it would violate public policy. And so you have to go to the grounds that are available under the New York Convention. The enforcement of arbitral award in a non-state party, when the CISG is determined as the law and the arbitration clause between the non-state contracting parties. But once again, I think that goes to the question of, can you deny recognition and enforcement because you believe that the arbitrators applied the wrong rules of private international law or went to the wrong law to decide the case? And I don't think the New York Convention leads you to that result. Again, unless you're able to claim that the result in the award is a violation of public policy, and that's something more egregious than just misapplying the law, I think. And so I think you have, this is where arbitration and the CISG come together and create the neat sorts of issues that have been Vis Moot problems. But I think that you have to realize that the grounds for non-recognition of an arbitral award are really very limited under the New York Convention and under the UNCITRAL model law, and they're limited for a purpose because parties choose arbitration because they don't want constant appeals and second look at the decision.
Okay, thank you. Thank you very much for the answer. I think it's a good point for conclusion, unless any of the panelists might have any complimentary final note. Please let me know. Hamid, Patricia, Professor.
Let me just wish all the Moody's who are going to be in your wonderfully arranged pre-moot. I hope they have a great experience in the next couple of days. I'm sure they will.
Excellent. Excellent. So thank you very much, everybody. And I really appreciate your presence in this event. And I wish good luck for the mooters and for the participants from tomorrow and the day after tomorrow. I hope that would be a great experience for them, and I wish them luck in the Vis Moot. So thank you very much. Have a great day. Goodbye.